Question 1. Copyright protection in digital media during a critical transition period where existing processes for protecting copyrighted materials are evolving due to digital distribution platforms. A filmmaker discovers that a streaming service has used his work without permission. The company claims they modified the content enough to qualify for transformative fair use under the U.S. Copyright Act. Under which legal principle should the filmmaker challenge this claim? A. The derivative work doctrine, arguing that even transformative modifications require authorization. B. The first sale doctrine, stating that once a work is sold, the buyer can redistribute it freely. C. The merger doctrine, asserting that the idea and expression of the film are inseparable. D. The scenes a faire doctrine, which states that common elements of genre are unprotected. Answer A. The derivative work doctrine, arguing that even transformative modifications require authorization. Explanation. The derivative work doctrine 17 U.S.C. SS 106 2 states that only the original copyright holder has the exclusive right to prepare derivative works, even if the work has been altered. Transformative use under fair use 17 U.S.C. SS 107 does not automatically mean the use is lawful. It must meet all fair use factors, including market impact. Option B is incorrect because the first sale doctrine 17 U.S.C. SS 109 applies only to physical copies, not digital streaming or reproduction. Option C is incorrect because the merger doctrine applies to cases where an idea can only be expressed in one way, e.g. mathematical equations, not films. Option D is incorrect because scenes a faire refers to stock elements in genre, G. detective in war film, but does not excuse unauthorized use of full film. Key takeaway: derivative works must be authorized by the copyright owner unless they clearly meet all fair use requirements. Simply claiming transformation is not enough. Question 2. Patentability of AI-generated inventions. When implementing new protocols in a shared environment, an AI research company develops a new drug formulation entirely designed by an artificial intelligence system with no direct human intervention. The company applies for a patent listing the AI system as the sole inventor under current US patent law. What is the likely outcome of this application? A. The patent will be rejected because US law requires human inventors. B. The patent will be granted because the AI system meets all patentability requirements. C. The patent will be partially granted, but only if the human is listed as a co-inventor. D. The patent will be approved under international patent treaties that recognize AI inventions. Answer A. The patent will be rejected because US law requires human inventors. Explanation. Under 35 U.S.C. SS 100F and recent rulings such as Thaler v. Vidal 2022, the U.S. Patent and Trademark Office USTA has clarified that only natural persons can be inventors. AI-created inventions without any human intellectual contribution do not qualify for patent protection. Option B is incorrect because meeting novelty 35 U.S.C. SS 102 non-obviousness 35 U.S.C. SS 103 in utility 35 U.S.C. SS 101 is not sufficient. An inventor must be human. Option C is incorrect unless the company proves human made significant contribution. Option D is incorrect because even international treaties like TRIPS and PCT follow the requirement of human inventorship. Key takeaway: AI-generated inventions face legal challenges in patent law requiring human oversight to qualify for protection. Question 3. Trademark likelihood of confusion. While analyzing the root causes of sequential problems in brand disputes, a small organic tea company named Nature's Harmony receives a cease and desist letter from a well-known health supplement brand, Harmony Naturals, claiming trademark infringement. Which of the following factors would be most critical in determining whether infringement has occurred? A. Similarity in sound, meaning an appearance between the two names. B. The length of time both companies have used their respective trademarks without conflict. C. Whether one company holds an international trademark registration under the Madrid Protocol. D. Whether the tea company sells a patented product that differs from supplements. Answer A. Similarity in sound, meaning an appearance between the two names. Explanation. The Lanham Act 15 U.S.C. SS 1114 and SR 1125 they governs trademark infringement, focusing on the likelihood of confusion test. Key factors include similarity of the marks, sound, appearance, and meaning, similarity of the goods services, tea versus supplements both fall under health-related products, strength of the senior mark, Harmony Naturals has established reputation, evidence of actual confusion among consumers. Option B is incorrect because long-term use does not necessarily prevent infringement. Option C is incorrect because international registration does not override domestic trademark laws. Option D is incorrect because patent has no bearing on trademark disputes. Key takeaway: trademark cases focus on consumer confusion, and similar names in related industries are likely to create legal issues. Question 4. Topic: patent infringement and remedies during a critical transition period where existing processes must be reevaluated for compliance with new technological advancements. A pharmaceutical company, Medicotech Inc., has developed a groundbreaking cancer treatment drug. The company holds a patent for the drug's chemical composition and its method of synthesis. However, another company, Biopharm Solutions, begins producing identical drug, claiming that it used slightly modified chemical compound that differs in one molecular bond from Medicotech's patented formulation. Medicotech sues for patent infringement. Biopharm defends itself by arguing that the modification constitutes significant change, making the new drug non-infringing. Under patent law, how would court likely rule in this case? A. Biopharm Solutions is liable for patent infringement because slight modifications do not necessarily avoid infringement under the doctrine of equivalence. B. Biopharm Solutions is not liable for infringement because altering single molecular bond creates legally distinct invention. C. Medicotech cannot sue for infringement because the patent only covers the exact chemical composition, not minor variations. D. Biopharm Solutions is liable for patent infringement only if Medicotech can prove Biopharm directly copied its exact formulation. Answer A. Biopharm Solutions is liable for patent infringement because slight modifications do not necessarily avoid infringement under the doctrine of equivalence. Explanation: under the doctrine of equivalence, minor modifications to a patented invention do not necessarily avoid liability if the altered version performs substantially the same function in substantially the same way to achieve substantially the same result. Graver Tanken MFG. Company v. Lind Air Products Company, 1950. Even though Biopharm modified a single molecular bond, if the drug still works in a nearly identical way to Medicotech's patented formulation, it would likely be considered infringing. The patent protects the underlying innovation, not just the exact chemical formula. Option B is incorrect because merely changing one molecular bond does not automatically result in legally distinct invention. Courts look at whether the essence of the invention has been copied. Option C is incorrect because patents can cover broader concepts beyond just the literal wording of the claims. Option D is incorrect because direct copying is not required to establish infringement under the doctrine of equivalence. Question 5. Topic: copyright infringement and fair use doctrine. While investigating a complicated issue between different media production companies, a documentary filmmaker, Alex, includes 15 seconds of a copyrighted song in his documentary without obtaining a license. The song is used during a historical montage to illustrate a cultural movement. The music label that owns the rights sues Alex for copyright infringement, demanding damages. Alex argues that the use falls under the fair use doctrine. Based on U.S. copyright law, how should the court assess this claim? A. The court will rule in Alex's favor because using only 15 seconds of song automatically qualifies as fair use. B. The court will reject the fair use claim because any unlicensed use of copyrighted material is automatically infringement. C. The court will apply four-factor fair use test considering the purpose of use, nature of the work, amount used, and market impact. D. The court will rule in favor of the music label because use of copyrighted material is never fair use. Answer: C. The court will apply a four-factor fair use test considering the purpose of use, nature of the work, amount used, and market impact. Explanation: fair use is assessed using a four-factor test outlined in 17 U.S.C. SS 107. Purpose and character of use. Non-profit, educational, or transformative uses. E.g. commentary, criticism, news reporting. Favor fair use. Nature of the copyrighted work. Highly creative works like songs receive stronger protection than factual works. Amount and substantiality. The more of work that is used, the less likely fair use applies. Effect on the market. If the use negatively impacts copyright holder's market, it is less likely to be fair use. Option is incorrect because no strict time limit automatically qualifies as fair use. Even short excerpts can infringe if they capture the heart of the work. Harper and Row v. Nation Enterprises, 1985. Option B is incorrect because U.S. law allows fair use exceptions. Option D is incorrect because some commercial uses can still qualify as fair use. Campbell v. Cuffrose Music, Inc., 1994. Question 6. Topic: trademark infringement and likelihood of confusion in an environment where different components must interact within a shared market. A luxury fashion brand, Elegance Company, sues a small startup, Eat Lux, for trademark infringement. Elegance Company claims that consumers might confuse Eat Lux's brand with its own, leading to market dilution. Eat Lux argues that its name is sufficiently distinct and that it targets an entirely different consumer base. What legal standard will the court most likely apply to determine whether trademark infringement has occurred? A. The court will examine whether Eat Lux intentionally copied Elegance Company's brand. B. The court will apply the likelihood of confusion test, analyzing factors like brand similarity, product overlap, and consumer perception. C. The court will rule in favor of Eat Lux if it proves that its customers do not overlap with Elegance Company's customers. D. The court will decide in Elegance Company's favor automatically because well-known brands have stronger protection against trademark disputes. Answer: B. The court will apply the likelihood of confusion test, analyzing factors like brand similarity, product overlap, and consumer perception. Explanation: trademark infringement cases are evaluated based on the likelihood of confusion test established in Polaroid Corp. v. Polar Adelex Corp. 1961. Courts consider factors such as strength of the senior mark, Elegance Company's brand reputation, similarity of the mark. In Lux versus Elegance, similarity of the goods services are both companies selling fashion products. Evidence of actual confusion, consumer sophistication. Option is incorrect because intent is not a required element for trademark infringement. Option C is incorrect because even non-overlapping customers can lead to brand dilution and confusion. Option D is incorrect because fame alone does not automatically result in infringement. A likelihood of confusion must still be proven. Question 7. In a scenario where efficiency decreases across multiple jurisdictions due to varying trademark registration requirements, a multinational company faces challenges in securing brand protection worldwide. The company wants to expand its trademark portfolio while ensuring that its trademarks are recognized and enforceable across different legal systems. What is the most effective international mechanism for securing global trademark protection? A. The Madrid Protocol. B. The Paris Convention. C. The Berne Convention. D. The TRIPS Agreement. Answer: A. The Madrid Protocol. Explanation: the Madrid Protocol provides a streamlined and cost-effective system for securing international trademark protection across multiple countries through a single application. Under this system, a trademark owner can apply for protection in multiple member countries using a single filing in their home jurisdiction. The Paris Convention (B) establishes national treatment but does not provide a unified registration process. The Berne Convention (C) deals primarily with copyrights, not trademarks. The TRIPS Agreement (D) sets minimum IP protection standards but does not offer a unified trademark register. Question 8. While analyzing the root causes of sequential problems in patent infringement cases, a court is asked to determine whether a new software feature infringes on an existing software patent. The defendant argues that software patents are inherently invalid under U.S. law. How should the court assess the validity of the patent, and what is the key legal precedent? A. Apply the Alice test to determine patent eligibility. B. Use the fair use doctrine to allow unrestricted use. C. Consider the Lanham Act for trademark protection. D. Apply the first sale doctrine to determine ownership rights. Answer: A. Apply the Alice test to determine patent eligibility. Explanation: under Alice Corp. v. CLS Bank International 2014, the U.S. Supreme Court established a two-step test for determining the patentability of software and abstract ideas. Determine whether the claim is directed to an abstract idea, e.g., mathematical formulas, business methods. If the claim involves an abstract idea, check whether it contains an inventive concept that transforms it into patent-eligible application. The fair use doctrine, B, applies to copyright law, not patent law. The Lanham Act governs trademarks, not patents. The first sale doctrine, D, applies to resale rights of copyrighted works, not patents. Question 9. During a major transformation where existing methods of trade secret protection are being re-evaluated, a company is concerned about potential misappropriation of trade secrets by former employees. What is the most effective legal strategy to prevent trade secret leaks? A. Rely on copyright law to protect trade secrets. B. Enforce strong non-disclosure and non-compete agreements. C. Register trade secrets with the U.S. Patent and Trademark Office. D. Allow reverse engineering to determine whether a secret remains valid. Answer: B. Enforce strong non-disclosure and non-compete agreements. Explanation: trade secrets are protected without registration, but they require reasonable efforts to maintain secrecy. Uniform Trade Secrets Act and Defend Trade Secrets Act. The most effective way to prevent misappropriation is through non-disclosure agreements, NDAs, and non-compete clauses. Copyright law A does not protect trade secrets. Trade secrets cannot register. C. Unlike patents and trademarks, reverse engineering D is often legal unless prohibited by a contractual agreement. Question 10. In a case where multiple parties have different objectives regarding the use of a copyrighted work, a company argues that its use of copyrighted content falls under fair use. Which of the following is the most critical factor courts consider when determining fair use? A. The commercial nature of the use. B. The transformative nature of the use. C. The duration of copyright protection. D. The international status of the copyright owner. Answer: B. The transformative nature of the use. Explanation: courts primarily evaluate fair use using a four-factor test under 17 U.S.C. SS 107. The transformative nature of the use. Whether the new work adds something new with different purpose or character is the most significant factor. Commercial use is considered but does not automatically disqualify fair use. Copyright duration C is relevant to protection length, not fair use. International status of the owner D has no bearing on fair use. Question 11. When implementing backup procedures across various digital platforms, a company faces challenges in protecting software code under copyright law. What is the key legal doctrine that determines whether software code is protectable under copyright law? A. The idea-expression dichotomy. B. The merger doctrine. C. The useful article doctrine. D. The exhaustion doctrine. Answer: A. The idea-expression dichotomy. Explanation: under 17 U.S.C. SS 102b and case law e.g. Baker v. Selden 1879, the idea-expression dichotomy states that copyright protects only the original expression of ideas, not the ideas themselves. The merger doctrine B applies when an idea can be expressed only one way, limiting copyrightability. The useful article doctrine C applies to design patents, not software. The exhaustion doctrine D applies to it. Question 12. During an emergency response where multiple areas are impacted by a trademark dispute, a well-known brand argues that a competitor's product creates a likelihood of confusion. What is the key test courts use to determine whether trademark infringement has occurred? A. The Polaroid test. B. The first sale doctrine. C. The fair use doctrine. D. The work for hire doctrine. Answer: A. The Polaroid test. Explanation: courts assess likelihood of confusion using the Polaroid test from Polaroid Corp. v. Polaroid Electronics Corp. 1961, which examines factors like strength of the mark, similarity of the marks, proximity of the products, evidence of actual confusion. First sale doctrine B applies to resale, not infringement. Fair use doctrine C applies to descriptive use, not likelihood confusion. Work for hire doctrine D applies to copyright ownership, not trademarks. Question 13. In a high-stakes environment where multiple challenges arise in enforcing international patent rights, a biotech company wants to protect its patents globally. What is the most effective international framework for patent protection? A. The Patent Cooperation Treaty (PCT). B. The Berne Convention. C. The Lanham Act. D. The Digital Millennium Copyright Act (DAE). Answer: A. The Patent Cooperation Treaty (PCT). Explanation: the PCT simplifies international patent applications by allowing inventors to file a single application for multiple countries. Berne Convention B applies to copyright, not patents. Lanham Act C governs U.S. trademarks, not international patents. DAA deals with digital copyright enforcement, not patents. Question 14. In a multi-location scenario where consistency requirements vary, a global technology company is concerned about potential copyright violations in different countries. Given that copyright laws differ by jurisdiction, which international treaty provides the most effective framework for harmonizing copyright protections worldwide? A. The Berne Convention. B. The Lanham Act. C. The Uniform Trade Secrets Act. D. The America Invents Act. Answer: A. The Berne Convention. Explanation: the Berne Convention for the Protection of Literary and Artistic Works, 1886, is the key international agreement governing copyright protection. It mandates that Automatic protection. Copyright exists upon creation without the need for formal registration. National treatment. Countries must grant foreign authors the same rights as their own citizens. Minimum standards. Includes exclusive right, reproduction, distribution, and adaptation. The Lanham Act B governs U.S. trademark law, not copyright. The UTSA C applies to trade secrets, not copyright. The America Invents Act D reformed U.S. patent law but does not deal with international copyright protection. Question 15. When developing a solution that must address opposing needs in patent licensing, a pharmaceutical company negotiates a cross-licensing agreement with another firm. What is the key advantage of cross-licensing in patent law? A. It allows both parties to use each other's patents without infringement. B. It grants exclusive rights to one party while restricting the other. C. It eliminates the need for regulatory approval. D. It removes the need for royalty payments in all cases. Answer A. It allows both parties to use each other's patents without infringement. Explanation. Cross-licensing agreement is mutual exchange of patent rights between two companies. This strategy is often used in industries with complex patent landscapes, e.g., pharmaceuticals, semiconductors, to avoid litigation and foster innovation. It does not grant exclusive rights. B. Instead, it allows both parties to operate freely. Regular approval, C, may still be required depending on the industry, e.g., FDA for drugs. Royalty payments, D, may still apply if the licensing terms are not entirely reciprocal. Question 16. While examining inconsistencies across various units in a multinational corporation, legal teams discover that one subsidiary uses an expired patent. What happens to a patent once it expires? A, enters the public domain and can be freely used. B, the original owner retains exclusive rights indefinitely. C, it can be renewed if the owner files an extension. D, the government assigns it to another entity. Answer A, enters the public domain and can be freely used. Explanation. Once a patent expires, typically after 20 years for utility patents in the US, the invention becomes part of the public domain, meaning anyone can use, produce, or sell the invention without the patent holder's permission. The original owner cannot extend exclusive rights except in rare cases, e.g., patent term extensions for drugs. The government does not reassign patents. D. This principle encourages innovation and competition by allowing others to build on expired patents. Question 17. During the introduction of new methods where coordination is critical, a company modifies an open source software program and distributes it commercially. Under which open source license might the company be required to share its modified code? A. GNU General Public License, GPL. B. MIT license. C. Creative Commons license. D. Trade Secret Protection. Answer A. GNU General Public License, GPL. Explanation. The GPLA, a copyleft license that requires any modifications or derivative works to be licensed under the GPL when distributed. This ensures that the software remains open source. Users have access to the modified source code. The company cannot privatize the modifications. The MIT license, B, is more permissive and does not require sharing modifications. Commons C applies to creative works, not software. Trade secret protection, D, is incompatible with open source licensing. Question 18. In a situation where formal requirements conflict with practical business needs, a startup wants to protect its product name but does not have the resources for formal trademark registration. What common law protection might still apply? A. Rights based on prior use in commerce. B. A temporary trademark valid for 5 years. C. An international trademark automatically recognized worldwide. D. Protection under the Patent Cooperation Treaty. Answer A. Rights based on prior use in commerce. Explanation. In the US, trademark rights arise from actual use in commerce, even without registration. These common law trademark rights provide geographic protection in areas where the mark is used, enforcement rights against later users with conflicting marks, the ability to file for federal registration later, which expands protection. There is no temporary trademark. B. International trademarks. C. Do not automatically exist. Registration is needed. The PCT D applies to patents, not trademarks. Question 19. While managing a hybrid approach where timing issues affect patent filings, a company wants to protect an invention before publicly disclosing it. What is the best legal strategy to secure protection before filing a full patent application? A. File a provisional patent application. B. Wait until the product is commercially successful. C. Publish the invention online to establish ownership. D. Use a trade secret instead of a patent. Answer A. File a provisional patent application. Explanation. A provisional patent application establishes a priority date for the invention, gives the applicant 12 months to file. A full, non-provisional application protects against early public disclosures that could bar later patenting. Waiting. B. Risks loss of patent rights if someone else files first. Publishing. C. Makes the invention unpatentable in most cases. Trade secrets. D. Do not provide the same level of legal protection as patents. Question 20. During a seamless transition where continuity must be maintained, a business wants to transfer copyright ownership of a work to another entity. What is the correct legal method to achieve this? A. Execute a written assignment agreement. B. Simply inform the U.S. Copyright Office. C. Rely on verbal confirmation between parties. D. Register the copyright with a new owner's name. Answer A. Execute a written assignment agreement. Explanation. Under 17 U.S.C. SS 204A, copyright ownership transfers must be in writing and signed by the copyright owner. This ensures clear documentation of ownership transfer, legal enforceability in case of disputes. Informing the Copyright Office. B. Does not transfer ownership. Verbal agreements. C. Are not legally valid for copyright transfers. Changing the registration name. D. Does not legally transfer ownership. Question 21. When implementing new protocols in a shared environment, a consortium of AI companies collaborates to develop a machine learning algorithm. They wish to protect their collective work under intellectual property law. What is the best method to ensure shared ownership and control over the algorithm? A. File a joint patent application. B. Register a single author under copyright law. C. Keep the algorithm as a trade secret without documentation. D. Place the algorithm in the public domain. Answer A. File a joint patent application. Explanation. A joint patent application allows multiple inventors or entities to co-own a patented invention. This ensures all contributors have rights to use, license, or enforce the patent. Legal recognition of joint ownership prevents disputes over contributions. Patents offer stronger protection than copyright for algorithms. Copyright B. Protects the code but not the functional aspect. Algorithm. Keeping it secret. C. May be impractical if multiple entities need access. Public domain. D. Relinquishes all IP rights, which is not ideal for business control. Question 22. During a critical transition period where existing processes are being modernized, a fashion brand discovers that a competitor is selling identical designs under a slightly different label. What is the most effective legal action to stop this practice? A. File a trademark infringement lawsuit. B. Apply for a patent on the designs. C. Register the designs under copyright law. D. Use a non-disclosure agreement. And D. Answer A. File a trademark infringement lawsuit. Explanation. Trademark infringement occurs when another party uses a mark, such as a logo or brand name, that is confusingly similar to an existing trademark. This can lead to consumer confusion about the origin of products, loss of market share for the original brand, legal grounds for monetary damages, and injunctive relief. Patents B are for inventions, not product designs. Copyright C might apply to artistic elements but is weaker than trademark law for branding disputes. N-D are for confidential business dealings, not public sales. Question 23. While analyzing the root causes of sequential problems in brand identity, a software company finds that its competitor has registered a domain name using its trademarked brand name. What legal doctrine can the company use to recover the domain name? A. Cyber-squatting laws under the Anti-Cyber-Squatting Consumer Protection Act (ACPA). B. Copyright infringement claims. C. Trade secret litigation. D. First to file patent rules. Answer A. Cyber-squatting laws under the Anti-Cyber-Squatting Consumer Protection Act (ACPA). Explanation. The ACPA 1999 protects businesses from cyber-squatting, which occurs when a third party registers a domain name identical or confusingly similar to a trademark name with bad faith intent. Companies can file or complain, uniform domain name dispute resolution policy for domain recovery, seek statutory damages of $100,000 per domain name. Copyright B does not apply to domain names. Trade secrets C do not cover publicly available names. Patents D are unrelated to domain disputes. Question 24. In a high-stakes environment where multiple challenges arise, a biotech company wants to protect its pharmaceutical formula but avoid public disclosure. What is the best form of intellectual property protection, in this case, A. Trade secret protection, B. Copyright registration, C. Design patent application, D. Trademark registration? Answer A. Trade secret protection. Explanation: trade secrets protect valuable, confidential business information without public disclosure. This is ideal for pharmaceutical formulas, manufacturing processes, and proprietary methods. Unlike patents, trade secrets have no expiration date. Protection lasts as long as secrecy is maintained. Famous example is the Coca-Cola formula, which remains trade secret. Copyright B is applicable to functional inventions. Design patents C only cover the ornamental appearance of products. Trademarks D protect branding, not product formulas. Question 25. During an emergency response where multiple areas are impacted, an environmental technology firm develops a rapid oil spill cleanup method. What is the best IP strategy to protect its invention while allowing public benefit? A. File a patent and license it for controlled commercial use. B. Keep the method a trade secret indefinitely. C. Publish the method for open source access. D. Rely on copyright protection for legal security. Answer A. File a patent and license it for controlled commercial use. Explanation: by filing a patent, the company can secure exclusive rights for up to 20 years, license the technology to governments, and then goes for controlled use, ensure financial return while enabling public benefit. Trade secrets B. might hinder widespread adoption. Open source C. relinquishes control and revenue potential. Copyright D is not applicable to functional inventions. Question 26. While investigating a complicated issue between different entities, a film studio finds that unauthorized streaming websites are distributing its movies. What is the best legal action to remove these sites? A. File a Digital Millennium Copyright Act DEA 8-down notice. B. Register the films under trademark law. C. File for a design patent on the movie titles. D. Enforce fair use policies against the sites. Answer A. File a Digital Millennium Copyright Act DEA takedown notice. Explanation: the DSEA allows copyright holders to demand removal of infringing content from websites and search engines. The studio can issue takedown notices to hosting platforms. Failure to comply can result in lawsuits against the site owners. Trademarks B. do not protect movie content. Design patents C. do not apply to creative works. Faye D. does not justify full movie streaming without authorization. Question 27. In a situation where resource allocation becomes critical, a video game company wishes to protect its game mechanics from being copied. What is the most effective legal strategy? A. File a utility patent for the game mechanics. B. Rely on copyright protection alone. C. Use a trademark for the game's title. D. Publish the mechanics to establish ownership. Answer A. File a utility patent for the game mechanics. Explanation: utility patents can protect novel and functional aspects of game mechanics. This strategy is effective for new gameplay systems, AI behaviors, or interface designs used by companies like Nintendo and Activision for game innovations. Copyright B protects artistic content, not mechanics. Trademarks C protect branding, not functional elements. Publishing D with legal protection allows copying. Question 20. While updating traditional approaches where interconnections between brands are complex, a beverage company wants to prevent competitors from using a similar slogan. What is the best protection method? A. Trademark registration. B. Copyright protection. C. Trade secret laws. D. Patent filing. Answer A. Trademark registration. Explanation: a trademark protects brand names, slogans, and logos that distinguish a product in commerce. Examples include Nike, and I'm loving it. McDonald's. Federal trademark registration grants nationwide protection. Copyright B does not cover short slogans. Trade secrets C are not useful for marketing phrases. Patents D do not apply to branding. Question 29. During an innovative expansion where multiple stakeholders contribute, a software company creates an AI-powered music composition tool. The tool generates unique music tracks without human input. Who owns the copyright to the generated music under current intellectual property laws? A. The company that developed the AI tool. B. The AI itself as the creator of the work. C. No one, as AI-generated works are in the public domain. D. The user who inputs data into the AI system. Answer A. The company that developed the AI tool. Explanation: under current intellectual property laws, Copyright law requires human authorship. AI alone cannot hold copyright. The entity that created and trained the AI system, usually a company or developer, holds ownership rights. If a user significantly modifies AI-generated content, they may have a claim, but it depends on jurisdiction. AI itself, B, cannot be a legal owner under present laws. Public domain, C, does not apply automatically. Ownership depends on legal frameworks. Users, D, typically do not gain ownership unless they contribute creative input. This area is evolving and laws may change as AI technology advances. Question 30. While addressing a pressing issue where legal precedence is unclear, a pharmaceutical company discovers that a competitor is producing a generic version of its patented drug before the patent expires. What legal action can the company take to enforce its patent rights? A. File a patent infringement lawsuit. B. Issue a cease and desist letter without further action. C. Request a design patent on the drug's packaging. D. Allow the generic company to proceed under fair use. Answer A. File a patent infringement lawsuit. Explanation. A patent infringement lawsuit is the strongest action because patents grant exclusive rights for up to 20 years from the filing date. If the generic version is made before patent expiration, it constitutes infringement. The court can issue an injunction stopping sales and awarding damages. A cease and desist letter, B, is the first step but not legally binding. A design patent, C, only protects appearance, not the drug itself. Fair use, D, does not apply to patented pharmaceuticals.